Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about request for more evidence and what to do if you received one. A request for more evidence is a very common document that most applicants for immigration benefits in the United States would receive during the process. Sometimes it comes on a white paper, sometimes it's printed on a yellow paper. It lists how much time you have to answer it. It states where you need to mail the answer and documents to, and it also, of course, states what particular evidence is missing from your case. Very often I receive questions from people who call me and state, I received an RFE, but it's actually asked for the same documents that I already provided to USCIS. Do I have to provide them again? The answer is yes. You do have to provide them again. Even though it's annoying and time-consuming, if you do not provide documents in connection with the RFE that was sent to you, your application will be denied. And the only thing that will be left for you to do afterwards is to file a motion to reopen and spend hundreds of dollars and waste more time. So even though and if an RFE asks you to provide the same documents that you already provided, you still have to respond to it. Another important point, do not miss the deadline, even by 1 day. You have to comply with the deadline because it's another ground for denial of your entire case. Is it possible to ask for more time to respond to evidence, to submit your response to an RFE? Usually it's not, and I would not advise that, and I would not risk it. It's not because very often when you receive a request for more evidence, you do not know who is assigned to your case, where this person is physically located, and you cannot contact them, so there is no this personal connection, and there is no guarantee that your request will be honored. That's why it's better not to risk it and to submit the requested evidence within the time that is given to you. Every notice will say specifically how much time you have to submit the evidence. Third and most important point, what actual evidence you need to supply to win your case when you receive a request for more evidence. It actually depends on each particular case and on facts of your case and what is possible for you to provide in this specific case. Sometimes the RFEs are very simple. They request for a copy of the birth certificate. But even with those RFEs, there may be questions. Let's say, what if you never had a birth certificate? Then you will need to look what substitutes under the law will be valid, that will comply with the law, and that will be accepted by USCIS instead of a birth certificate. Sometimes an RFE is really containing a legal question. You have to meet a legal threshold by providing certain evidence, and you will need to either educate yourself on this law or go to an attorney. For example, in employment-based cases, there is such a point as an ability to pay. An employer who is sponsoring you for a green card has to prove to USCIS that it has ability to pay the salary that is listed in your certification. And USCIS will state that you need to provide either tax returns that show that employer has or had sufficient money, or pay stubs if employer has been employing you already. Guess what? There are other evidence that you can provide which will not be listed in that RFE as examples, or other ways to prove ability to pay other than the full year tax return, and it's not listed as an example in request for more evidence. But how would you know that? Not even many lawyers know that. It requires years of research and experience to and stay focused and on top of the current law to be able to ascertain, to be able to understand which evidence you may collect in your specific case to comply with the law. For example, in the cases of ability to pay, there are different exceptions. Let's say an employer, the case has been pending for a while, and the law of course states that an employer has to prove ability to pay for each year of which the case was pending. And let's say 2012 was a great year, 13, 14 were a great year. In 2015, employer had no income, but in 16 and 17, employer started making money again. So what to do in this situation? Well, the case law states that the employer can ask USCIS to take all factors into consideration and make an exception for this short period of time. But request for more evidence would not tell you that. And that's why it's important to talk to an attorney if you face a situation like that. If you find this video helpful, please subscribe to our channel and visit our website www.shautsova.com. There you will find many different articles about various situations, and some articles I already published about RFEs and how to handle them. Thank you.